The next major gun battle begins. Welcome to another installment of Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms for NRA certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. And let's talk about this. Now, we all know the NYSRPA versus Bruen case and the ruling that came from it lessened the restrictions on applying for a carry permit to carry a firearm in the state of New York. And as we know, in response to that, especially in New York, there has been moves to restrict heavily where you can carry a firearm. If you remember, I did a video on Kathy Hochul, the governor of New York, signing off on a very restrictive carry policy for the state of New York. And then, of course, I did another one where basically the New York City Council, Eric Adams' his little collection of people, they basically banned all firearms in Times Square. Not for the criminals, though, just for the people who actually have permits. Because if you're a criminal, you're going to be running rampant anyway. But now, in anticipation of that, there's already been court filings to challenge where you can carry a firearm. And this has national implications. So, there's a CBS article here titled, Supreme Court's Gun Ruling Opens Door to Next Fight. Where can they be carried? And I'm not going to read all of this, but I'm definitely going to scan through some very interesting parts. But state laws prohibiting people from carrying firearms to insensitive locations are providing the foundation for the next battle involving the Second Amendment in the wake of the recent Supreme Court decision, with the question in the court shifting from whether Americans can have guns at home or in public to where they can be carried. Already, challenges to so-called sensitive place restrictions in New York and the District of Columbia have been filed, and more are expected to follow from gun rights supporters who argue the measures keeping them from bringing guns into places like houses of worship, on college campuses, and in public parks infringe on their right to keep and bear arms. Quote, that's going to be an important and interesting battlefield going forward for Second Amendment cases. Joseph Blasher, an expert on the Second Amendment and professor at Duke Law School, told CBS News. Until now, it has been a sleepy corner of Second Amendment law and scholarship, and that means there's going to be a lot of open questions to figure out. And the central one is, what makes a place sensitive such that the government can prohibit guns in that place? And that's a very, very important question, and I'm glad he asked that, because there is actual Supreme Court precedent for this, established precedent. Okay? Now, if I go down here, I'm going to come right to this section here. Justice Clarence Thomas, writing for the majority in the June decision, this was Heller versus D.C., cited few 18th and 19th century sensitive places in the historical records where guns were prohibited. Now, let's be clear. These were places that they said the states may ban them. They didn't say that they have to ban them. They said you can, if you wish, ban them in these places based on this law from the 18th and 19th century. So these were the places here. Legislative assemblies, that means government buildings where the legislature gathers to do nothing. Okay. Polling places where you go to vote, and courthouses. Okay. These have actually established law for these places. It says these states you can ban guns in these places. It doesn't say you must. It says you can ban guns in these places. But said, we therefore can assume it's settled that these locations were sensitive places where arms carrying could be prohibited, consistent with the Second Amendment. Could be prohibited. So New York, especially Hochul and Adams, going off and just designating, pointing and saying, sensitive place, can't carry, is not going to stand up to constitutional muster. But Justice Brett Kavanaugh, joined by Chief Justice John Roberts, also noted in a concurring opinion what he said were the limits of the Supreme Court's decision, including that the Second Amendment allows for a variety of gun regulations, among them laws prohibiting the carry of guns in sensitive places like schools and government buildings. But it doesn't stand up to actual precedent. Okay, and I'm going to go down to New York law passed after the Supreme Court invalidated its licensing rules. NYSRPA versus Bruen designates 20 categories of sensitive locations. So the New York City just kind of made up, or New York State just made up a bunch of places you can't carry. But where people cannot carry guns, among them any place of worship or religious observation, bars, ferries, banquet halls, public parks, and Times Square. The law, which took effect September 1st, quickly drew a legal challenge from the gun rights group Gun Owners America and its members P.A.N. and York, who argued that the state's new restrictions infringed on their Second Amendment rights. The scope of New York's list of sensitive locations, they wrote in their complaint, makes it hard to imagine how a carry license holder could so much as leave home without running afoul of the Concealed Carry Improvement Act. And I stated that. With the way this thing is written, you basically, if you leave your house, drive around and come back, you're good. You have to stop somewhere, you may be in trouble. You may be in violation of the law. That is precisely the result that Bruen warned about, because if you read Bruen, the Supreme Court kind of headed this off and immediately said, wait a minute, this could literally open the door to states doing exactly what New York did. If you read Bruen, it's actually in there where the court said, yeah, we expect you to do this. But while the federal judge in Syracuse dismissed the case in late August, he said the gun rights backers have a substantial likelihood of success on the merits of the case and wrote the law's list of sensitive location is not deeply rooted in a national historical tradition of firearm regulation. That's going back to Clarence Thomas, citing 18th and 19th century law and precedent from the court. In addition to the challenge from Gun Owners America, the New York State Jewish Gun Club is preparing to file its own lawsuit against the state over its restrictions on guns in sensitive spaces, which makes it a crime for congregants to carry firearms in synagogue. Quote, the focus of this sensitive place statute in New York is so overbroad and vague. It says you can't possess a weapon in a place of worship or religious observation, and it begs the question, what is a religious observation, said Amir Beno, a lawyer hired by the gun club to challenge the law. Quote, there's the Second Amendment right, but the fear that if you transgress that right, you could be prosecuted for a felony will chill people from exercising their religious freedoms. Makes sense. Okay? So, this is a big deal because there are a lot of states, Connecticut being one of them, that has restrictions on where you can carry a firearm. This goes to the Supreme Court. This is going to be a federal law. It's going to be a federal ruling, which means all those states that have these restrictions are going to be under fire to change them, or they're going to be dropped completely. So I kind of anticipated it. I said it right from the beginning when Hochul signed off on her little carry restriction law. I said, you basically can't carry anywhere in New York. You leave your house, you better be damn sure you know where you're going, and if it's legal or not for you to carry that gun there. So it's going to the Supreme Court. There's no doubt about it. And once again, they're going to use Bruen and Heller as the foundation for their decision. And as the judge said in Syracuse, the plaintiffs have a great case based solely on the merit, which is great news for the law-abiding gun community. I want to point out again that there was when the New York City Council was discussing the gun-free zone in Times Square, they had one of their representatives sitting there saying, I grew up in New York, and New York is, I just don't want to see it become the OK Corral. Here's a wake-up call. It is the OK Corral. Just because you don't live in the parts that are heavily affected by violence in general doesn't mean it's not happening. Now you had no problem with the rising crime in the city, but now you got a problem with a law-abiding person going through all the steps to obtain a permit, obtain a firearm legally. You have a problem with them carrying in Times Square, but not a criminal element that's been doing it anyway, and not the fact that your whole city is falling apart because of violence. Yeah, These people just seem to cherish the criminals more than they do the law-abiding. They make laws against those people and let the criminals run rampant and give them bail-free releases after they commit a crime, and usually a violent one. But you kind of got to get you can't wrap your head around these people. You can't figure them out. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I'll see you on the next one. Peace.